Yeah.
Hello, ladies and gentlemen. Welcome to our webinar number 10 in this year. This is the last webinar we are holding in the year 2020. What is today's topics? It's an update on Brexit and legal changes in trademark and design law as of January 1st, 2021. So this is a pretty hot topic. We're at the end of the year, and we thought we would summarize the issues for everybody listening in, because in less than 3 weeks, we will be approaching the IP Brexit. For all of you who do not know LexDellmeier, we are a boutique intellectual property law firm headquartered in the center of Munich. We are currently 9 IP experts and are dealing with trademarks, designs, copyrights, and we do prosecution and litigation. So I'm Alexandra Dellmeier, and together with my colleague Andrea Breyer, we will be hosting today's webinar. We are the speakers, and also in case you have questions, your so-called Brexit contacts. Andrea has 15 years of work experience. I myself have 23 years of work experience. And on the next slide, we're going to show you what today's agenda will be. So we're going to give you an overview of Brexit, so the situation until December 31st, and what changes are coming into force on January 1st, 2021. So what impact is Brexit going to have on trademarks? What impact is it going to have on designs? We're going to give you a conclusion and some recommendations and a checklist for you, and also where to find up-to-date information and give you some links so you can follow the whole topic, because there may be issues that may still be changed within the next couple of weeks. All right, let's start. Let's start with the overview on the Brexit. So first of all, what you need to know is there's a difference between the geographical scope of the EU until January 31st, 2020, and the legal implications. So we actually already had Brexit, because that happened as of February 1st, as you can see on the slide. So the UK actually detached itself from the EU. So this is what the map looks like. The UK is not a member of the EU as of February 1st of this year of 2020 anymore. However, there is a so-called transition period until December 31st of this year. So what I call it is the legal transition period, meaning that during this time, no changes have come into place. The reason is that Brexit did come a little quicker and a bit more surprising than it was planned for. And then the European Union and the UK decided, well, there's so many issues we still have to discuss and fix that we will need some more time. So that's for this reason, the past 11 months have been put into place to transition all the legal aspects that are still under discussion. So bottom line is that as of January 1st, 2021, there will be changes coming into force. And this is important here. So this is the overview regarding EU trademarks. So based on your European trademark that is registered with the EU IPO, the UK IPO will automatically create a comparable UK national trademark. So what will happen? You will remain the owner of the existing EU trademark, and in addition, receive a national UK trademark. So this is what you see here with these 3 circles at the bottom. Andrea, maybe you can circle. So what you have right now, until December 31st, you have the EU trademark with the 28 national EU member states. And what's going to happen is that it's going to be divided. So you're going to keep and be the owner and still be the owner of the EU trademark, but also receive an additional national British trademark. So this is what's happened, and that's like going to be happening automatically if you have a registered EU trademark. However, if you have an application pending, meaning that the trademark is not registered before the EU IPO, you're not going to get an automatic UK trademark. And this is where you need to put your attention and you may need to act. Andrea is going to go more into detail in the following slides, but if you have an application, you are not going to get a UK national trademark automatically, but you will have to apply for that. Okay, so maybe we'll go to the next slide. So, and what will happen if you don't have any trademark protection? You don't have an EU trademark at all, but you're going to apply for one starting January 1st, 2001, or after, starting on the 1st of January. So what's going to happen there? If you want protection in the UK and you want an EU trademark, then you will have to apply for both separately. That's the way you'll have to do it. And the details of all the changes and the implications, I'm going to hand over the word to Andrea, who will start with the topic Brexit and the impact on trademarks. Andrea, I'm going to hand over to you now.
Thank you, Alex. Welcome, everybody. Thank you for joining us to learn more about Brexit. There are so many issues involved with Brexit and intellectual property rights that it's impossible to put that all into one presentation of about 45 minutes. So we basically concentrated on an overview, on the very general issues. And if you have questions on any particular smaller issues, don't hesitate to contact us afterwards, and we'll be glad to discuss by email or phone your issues separately. For now, the most important thing is to keep in mind that date, 31st December 2020, for basically all issues, for renewal of your trademarks, for use, if you want to rely on a certain, on whether or not your trademark's well known, for everything, this particular date, 31st December 2020, is important to remember. And it's important to make a distinction between your registered EUTM trademarks and trademarks that are still pending before the EU IPO and have not yet been registered. Which effects will Brexit have on registered European Union trademarks? As Alexandra already mentioned, until 31st December of this year, your European Union trademark, which is registered, will be protected in all 27 member states of the EU plus the UK. Even though the UK has already left the European Union on 31st January 2020, so far everything's remained the same. However, starting 1st January 2020, your EU trademark will still be protected in all EU member states, the 27 that remained, but it will not have any protection in the UK anymore. So there will be a division of protection one trademark, your registered EUTM, will still enjoy protection in the EU member states. And the UK will be protected by a newly created national UK trademark. If you use, or if the issue of genuine use of your European Union trademark will come up, you have to remember that as of 1st January 2021, any use in the UK will no longer be considered use of your European Union trademark in the European Union. However, for any period before 1st January 2021, you can still rely on use in the UK. So whenever you have this 5-year period of use that for which you have to prove genuine use, make a make a timeline or something similar, and mark the dates. In particular, with dates, I mean the 5-year period. When does it begin? When does it end? And also mark 31st December 2020. Everything before 31st December 2020, or including 31st December, for that, use in the UK will also be deemed use of your European Union trademark. Everything that happened afterwards, from 1st January until the end of the time period for which you have to prove genuine use, for that, use in the UK cannot be regarded as use of your European Union trademark. So this will be very important to remember. And another important implication of Brexit regarding IP rights is that earlier national UK rights can no longer be used as basis of, for instance, an opposition or an invalidity proceeding at the EU IPO against an EUTM or EUTM application. Should your trademark, your European Union trademark application have been opposed in the past based on a UK right only, that proceeding will come to an end, automatically come to an end. If your trademark, your European Union trademark application has been opposed based on a UK trademark, but also in addition on an earlier, let's say, German trademark or European Union trademark, then unfortunately only the UK right will not be taken into account when the office decides about the UK, the opposition, but the opposition proceeding itself will continue. Starting 1st January 2021, the UK IPO will create a comparable UK trademark right for all registered European Union trademarks. You don't have to do anything. You don't have to file a new application. You don't even have to check any box anywhere. So as of 1st January, you will automatically own your European Union trademark with protection in the remaining 27 EU member states, plus your UK trademark. No additional registration fee has to be paid. Also, the UK IPO will not assess absolute or relative grounds for refusal. Unfortunately, there will also no UK registration certificate be issued. However, the details of your newly created UK trademark will be available online. The link can be found here. And you can, if you ever need to prove existence of your trademark, you can just print out the website and improve use. So at the end of, or as of 1st January 2021, based on one EUTM, you will then own one EUTM. Nothing will happen to that one. And in addition, one national UK trademark.
So Andrea, this is really interesting. So in essence, what the UK IPO is doing, they are cloning all registered European Union trademarks. Is my understanding correct here?
Exactly. In fact, the new UK trademark will have the identical mark as the registered EUTM. It will have the same specification of goods and services. It will have the same application date, and if the EUTM claims priority of any earlier application, also that priority date will be transferred to the UK trademark. Or not transferred, but cloned. And the renewal date will be the same. So the new UK trademark will have to be renewed on the same date as the registered EUTM. However, they have to be renewed separately, but we'll see that on one of the next slides.
So just to summarize that, so I'm going to have two trademarks and they're separated, meaning that as of separation, I will have to renew each one separately, and I will also have to docket separate deadlines, namely for each trademark. Is that correct?
Exactly, and that's very important just to keep track of everything. You should definitely have different trademark monitoring procedures in place for both trademarks, and not put everything in the same file, because it's so easy to lose track of, for instance, renewing the UK trademark. And once you've renewed the EUTM, you still think your UK trademark is fine as well. And then suddenly you realize, oh, it's not. So there should be a clear division of both marks.
So in essence, what I'm going to do is I'm going to open a separate file. So nowadays, everybody has a docketing system, an electronic system, because it is a separate intellectual property right. It's going to have its own number. So it makes sense to actually also, like the UK IPO is cloning the marks received from the EU IPO, that everybody who is responsible for European trademarks should clone those in their system too, and then add the numbering and download the register extract and have everything in order then.
Exactly. In fact, both trademarks will be completely independent of each other. Once the UK trademark comes into place, is established, is registered in the UK IPO register, it's completely independent of the registered EUTM. We already talked about use and the grace period of use, and the 5-year period of non-use for which you, or the 5-year period for which you might have to prove genuine use of your trademark in different proceedings. There will be no new 5-year grace period of non-use for the newly established UK trademark. So that's one important issue to remember. That will also be cloned. Any license or security interest that's recorded against your registered European Union trademark will continue to have legal effect in the UK as if it applied to the new UK trademark. Yeah, and important, but we already talked about that, the national UK trademark has to be renewed separately from the EUTM. But then it can be renewed every 5 years, open end. If your trademark your European Union trademark application has not yet been registered on 31st December 2020, it will not automatically be converted into a national UK trademark. It will also not automatically be converted into a new national UK trademark application. What you get is the possibility of filing a new national UK trademark application by keeping the priority date, the application date or priority date of your European Union trademark application. So if your European Union trademark application has not been registered by 31st or on 31st December, as of 1st January 2021, you can file a separate trademark application in the UK. And that registration procedure will be completely separate from the one for the corresponding EUTM application, which will of course also continue until the application is registered. Whether or not the new UK trademark application will need an address for service in the UK is still discussed in the UK. Our recommendation, however, is to file new applications not by yourself, but through UK attorneys, because first of all, they have all the accounts in place for paying, for receiving communication, but also in particular in these still uncertain Brexit times, we are of the opinion that it's important to have national representatives that are on top of all the issues and can take care of everything quickly and act quickly. So we recommend using UK attorneys for filing new applications, even though the legislation might not be changed over the next weeks. But as I said, whether or not an address for service will be needed in the UK, it's currently discussed, and there might be UK legislation be implemented at the beginning of next year.
So it's more or less similar as in most countries. Foreign attorneys or foreign counsel cannot act in that specific country. So in the long run, that's the way it's probably going to be. So in order to be secure and in order to do proper renewals or changes, it makes sense that for a national UK trademark, a national UK attorney is also engaged. In this content, just a hint for everybody who's listening, because you have an EU trademark application, you have to really keep this deadline in mind, the 30th of September of 2021, in order to be able to gain UK trademark protection. Bottom line is, and to make it simple, anybody who filed for an EU trademark application definitely as of September 2020 is probably and very likely not going to be published and registered by December 31st, 2020. So this means that anybody who's filed a EUTM application in the last quarter of the year will have to take a decision if they want, if the 27 member states left over after December 31st are sufficient, or if you want to have UK protection in addition, because then an additional fee and payment will be necessary, and you will have to claim this UK right by the 30th of September 2021. That's an absolute deadline, and there's no extensions.
Yeah, yeah, thank you, Alex. Of course, it will be possible to also file your trademark after 30th September, but then you will not be able to claim the application and priority date of the corresponding European Union trademark application. So this possibility of claiming the early application date and starting date of protection in case your trademark gets registered will only be given to you for filings until 30th September 2021. Okay. As I already mentioned earlier, the expiry date for your UTM will also be the expiry date for your UK trademark. Expiry date and renewal date are the same. So where your European Union trademark renewal date falls after 31st December 2020, here again, the important date to remember, early payment of the renewal fee at the EU IPO will have no effect in respect of the new UK trademark. So if you've renewed or intend to renew your European Union trademark between 1st July 2020 and 31st December 2020, but the actual expiry date is after 31st December 2020, your early payment will only renew the European Union trademark, but it will have no effect on the new UK trademark. You will have to renew the UK trademark separately to enjoy protection in the UK for another 10 years. So check your file. If you have, and first determine when is the expiry date and the renewal date for my European Union trademark. If it is before 31st or including 31st December 2020, check if you've already paid. If you have already paid, you're fine. Your European Union trademark has been renewed, and your UK trademark will not need any separate renewal. If your expiry and renewal date is after 31st December 2020, so as starting 1st January 2021, check if you have already paid. Have you already paid? Only your EUTM will have been renewed, but you have to pay separate renewal fees for the UK trademark. And
From my side, just as a short comment, we do have quite a few clients. We remind them that their European trademark is up for renewal. And we are able to make payments to the EU IPO 6 months prior to the renewal date. So this is an important issue. So for everybody who is an EUTM trademark holder or who is advising clients and as a representative, to really look through your portfolio and take a look when the expiry date or the renewal date is, because we are not certain. We don't know if the cloning, if everything will be in good order. There are many, many marks that need to be cloned. We are not certain if the UK IPO will actually also send out separate renewal reminders for the national UK trademarks. So you really have to be on top of this and take a look. It's not an easy issue. And if the UK is important for you, and you know that you're going to have a separate UK national trademark, take a close look at the renewal date, and if the UK has been covered by the original renewal fee that was paid before December 31st. If not, then you may have to file a renewal fee for the UK nationally.
this is just another summary of what we just talked about. Actually, if your trademark, if the expiry and renewal date is on or before 31st December 2020, then any late payment of the renewal fee will also renew the UK trademark. However, if your renewal date is between 1st January 2021 and 30th June 2021, you will have to, as of 1st January 2021, you will have to renew your UK trademark separately at the UK IPO. Usually the UK IPO sends out renewal reminders 6 months before the renewal deadline. For any trademarks that UK trademarks that expire between 1st January 2021 and 30th June 2021, this 6-month period can naturally not be kept. So there's like something like a security provision in place, and the UK IPO says that will only send out renewal reminders on the expiry date of your trademark, but will give you the chance for late renewal of your trademark without having to pay late renewal fee. But that's an exception only for new UK trademarks that expire between 1st January 2021 and 30th June 2021. We'll have to see if that can, how that plays out in practice.
In practice, no, but the question is also if technically everything is going to work, and sending out all those reminders, if all the emails will be, so the whole transfer and the whole technical issues, if that works, and if the UK IPO will actually be able to stem something like that, is questionable. And also, for this reason, this is another reason for liability issues, to actually engage UK counsel who have everything implemented, who have access to the UK IPO, who will be informed and are on the ground and can be of service there.
Exactly. So what if you don't own a direct European Union trademark, but have designated the European Union in an international trademark registration? Well, international trademark registrations designating the EU will basically be treated as just like national European Union trademarks. Until 31st December 2020, they will be protected in all 27 member states of the EU plus the UK through the EU designation of the international registration. And as of 1st January 2020, protection of the international registration designating the EU will only be for the 27 remaining member states of the EU. But in addition, you will get a national UK trademark. So just like with the registered European Union trademarks, your international registration designating the EU will be transferred into a national UK trademark right. It will not be an the UK trademark will not become part of your international registration, but it will be a national UK trademark right where renewal fees and all other administrative issues need to be addressed at the UK IPO. Here again, conclusion: based on one EU designation of the international registration, you will then own one EU designation of the international registration, protected in the 27 EU member states, plus one national UK trademark. The new UK trademark created from the international trademark designating the EU will also be identical to the EU designation. It will have the same signs, same list of goods and services, same application date, same priority date, same expiry and renewal date. And since the new UK trademark right is not part of your international registration, renewal has to be effected at the UK IPO. It cannot be affected by paying the renewal fee with WIPO. Of course, there's also the possibility that your international trademark application will not have been granted protection by the EU IPO by 31st December 2020. In that case, it will be treated like a European Union trademark application, and you have to file a separate national trademark application in the UK to gain protection there. Again, you have that 9-month period until 30th September 2020 to file such a new UK trademark application, and you can use the application and priority date of the international registration designating the EU to keep that early date of protection. That's it for trademarks. But there are also registered community designs, registered and unregistered community designs. So what happens to those regarding Brexit? It's essentially the same as with EUTMs. Until 31st December 2020, again, that important date, remember, your registered and fully published registered community design will have protection in all 27 member states of the European Union plus the UK as of 1st January 2021. Protection of the registered community design will only cover the remaining 27 member states of the EU. However, in addition, you will get a national UK design which will be newly created by the UK IPO. So based on one registered community design, as of 1st January 2021, you will own that one registered community design plus one national UK design. If your registered community design has been, or if the EU has been designated in an international design registration, the same as with trademarks again, it will be treated as a registered community design and will be converted into a national UK trademark. So also based on one international design registration designating the EU, you will also own that one international design registration covering the remaining 27 EU member states, plus one national UK design. Those new national UK designs are completely independent from the registered community design. And they will also need to be renewed separately. Same term as with the community designs, every 5 years up to a maximum of 25 years. If your community design application has not yet been registered on 31st December 2020, it can be refiled identically as a national UK design application. And if you do that until 30th September 2021, you may also claim the application and priority date of the original registered community design application. If you don't file by 30th September, your design will not be protected in the UK, because even if the registered community design application is the community design application will finally get registered by the EU IPO, it will obviously not extend to the UK. So for separate protection in the UK, you need to file a separate application there. And keep in mind that you might want to do that by that 30th September 2021 deadline, because otherwise your design might not be new anymore. Depends on the circumstances. Oops, sorry, too fast. Unregistered community designs. As you know, in the European Union, we have a special situation. Unregistered community designs can be obtained by simply disclosing designs in the European Union. If such an unregistered community design has come into existence on or before 31st December 2020, it will be protected for a total of 3 years from its coming into existence. Until 31st December 2020, the unregistered community design will be protected in all 27 member states of the EU, plus the UK. As of 1st January 2021, it will still be protected in the 27 EU member states, and the UK will also, in addition, automatically create a national unregistered UK design, which will be protected for the remainder of the 3 years that the registered community design, the unregistered community design is protected. So if your unregistered community design has come into existence on 1st February 2020, it will be valid until 31st January 2023, 3 years. The national UK unregistered design that is established on 1st January will then not protect your design for 3 years as of starting 1st January, but will only protect your design until, what did I say, 31st January 2023. So the unregistered community design and the national unregistered UK design have the same starting date and the same end of protection. So far, the very basics. As I said, if any particular questions arise, don't hesitate to come back to us. And I'll hand over to Alexandra again for a conclusion on the Brexit issues. Thank you.
Thank you so much, Andrea, for showing us all of these issues. Now, we wanted to put together for you a conclusion, a recommendation, and a checklist and to-dos. We can do this because we have gone through the process. So we have been monitoring this Brexit issue for the past 10 months, I would say, and we've done some preparation work, which we would like to share with you, or what we think you should do, or what we have done in the past months already. So first of all, review your trademark and design portfolio in detail. The best is to actually start off in December, this month still, if it's still possible, if you have time to review the matter. If you do not have time now, then you should do that latest in January or in February. Then the second thing you should do, once you've reviewed your portfolio, clone your trademarks and designs that designate the EU. So either you have an EU trademark, then you should clone that. You will have then have two files, namely the EU trademark and the UK trademark. And this should be in your docketing system. Or you have designations of the EU in the international registrations. Then you will have an international registration file, and you will also have a separate UK file. Okay, it's not going to be designated within the UK, is not going to be designated within the IR, but you will have to open a separate national file in your docketing system. So once you've done that, then as of January 4th, because there's going to be some time that it's going to take the UK IPO. It's not going to happen overnight from the 31st of December till January 1st, but they're supposed to be up and running after January 4th. Then download your national UK rights. They should be downloadable. As Andrea had pointed out, the last 8 digits are identical to your EU trademark, and the front digits will be for trademarks 009. So you should easily be able to find the trademark or just enter the name. That should work too. Then maybe come to the next slide. Our recommendation also is to actually appoint UK counsel for UK trademarks and designs. As we discussed or pointed out, you may be able to do something by yourself. There may and probably will be some kind of 3-year transition period. But if you need to do something, file an opposition or an invalidity proceedings, you're definitely going to need UK counsel. So for security reasons, we would advise to appoint a UK counsel for those national UK marks. The other way around, if you have UK counsel that are representing your EU trademarks and EU designs, you have to ask those UK trademarks if they have an office or representative on EU ground, because they're going to lose the ability to represent EU trademarks or EU designs. So if you are dealing with national UK law firms, it may be problematic. You will have to appoint other counsel in order to take over representation of your EU rights. So it's under discussion right now, but that's the way it's going to be. Brexit means there is a separation, so there will be a separation of legal representation too. So contact your UK counsel and ask them if they're still able to continue to represent you or not. Question, of course, is also how do you keep up to date? And we wanted to put together for you 2 links from official sources. Those are the best sources to look at because there may still be changes coming up. We are at the end of the year. This is one of the main reasons why we decided to hold the webinar in December due to the close Brexit starting January 1st. But if you want to keep up to date and take a look what's happening, here are 2 links from the EU IPO and from the UK IPO. Please note, of course, if you're really nosy and want to see if you actually have a national UK right, please note that the UK IPO has already published on its website that it will not be working from 31st of December 2020, 11 p.m. until January 4th, 2021, 4 p.m. due to the maintenance and the duplication and cloning of the UK marks and designs based on the EU IPO's database. That's it for today. As this is the online version and the recording, we would just like to thank you very much for your attention. If you liked our webinar, please give us a thumbs up on YouTube. And if you have questions, Andrea and I always stay at your disposal. You're welcome to contact us via phone. You have the phone number here, or our email address, info@lexdellmeier.com. Yes, and again, thanks for listening in and hope you enjoyed the webinar. Thank you and bye-bye.
Bye.